This week, the United States Supreme Court heard arguments in a major case called Murphy versus Missouri out of the United States Court of Appeals for the Fifth Circuit. This got into the issue of, under the First Amendment's right to free speech, whether or not the federal government or governments can basically partner up with social media companies to work together to allegedly restrict the speech of viewpoints that they agree they don't like. And this came out of situations involving the COVID-19 vaccination, some of the election issues from 2020 and so on. And this was a big U.S. Supreme Court case involving the First Amendment. Now, what's very interesting here is I'm going to play clips, and I want you to listen carefully between, let's say, the applied views of Justice Sam Alito, who's very skeptical of the fact that government is coordinating with social media companies to convey a particular viewpoint, if you will, versus, let's say, hey, it seems like government can do whatever it wants from Justice Brown Jackson. Nevertheless, we'll see what happens. By the way, this issue is going to be one of the biggest issues in this case, is going to deal with the issue of standing, whether or not the plaintiffs had standing to get the relief they got. But I'm not going to talk about standing in this video. I'm going to talk about some of the back and forth between the court and the lawyers involving what the First Amendment means, what's coercive, what is cooperation, what does the First Amendment mean, not just in terms of restricting government, but does the First Amendment also give government rights to speak out on particular issues? We're going to talk all about this, and I'm going to let the Supreme Court justices do their own talking in this video right here and right now. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and author of Disarmed, What the Ukraine War Teaches Americans About the Right to Bear Arms. All right, so we're going to get right into this. The United States Supreme Court heard argument in Murphy versus Missouri, dealing with whether or not social media companies can team up or partner up with government to basically convey certain viewpoints and encourage viewpoints over others, whether or not this somehow violates the First Amendment rights of those individuals whose views on these social media platforms were suppressed or otherwise censored at the encouragement of government asking social media companies to censor or restrict the accessibility of certain viewpoints that the government disagreed with. And that's what this argument in Murphy versus Missouri was all about. So let's start right from the start. Let's see what Justice Alito had to say about this case in his discussion right here, right now.
Mr. Fletcher, when I read all of the emails exchanged between the White House and other federal officials and Facebook in particular, but also some of the other platforms, and I see that the White House and federal officials are repeatedly saying that Facebook and the federal government should be partners. We're on the same team. Officials are demanding answers. I want an answer. I want it right away. When they're unhappy, they curse them out. There are regular meetings. There is constant pestering of Facebook and some of the other platforms, and they want to have regular meetings. And they suggest, they suggest rules that should be applied, and why don't you tell us everything that you're going to do so we can help you and we can look it over. And I thought, wow, I cannot imagine federal officials taking that approach to the print media, our representatives over there. If you did that to them, what do you think the reaction would be? And so I thought, the only reason why this is taking place is because the federal government has got Section 230 and antitrust in its pocket, and it's, to mix my metaphors, and it's got these big clubs available to it. And so it's treating Facebook and these other platforms like they're subordinates. Would you do that to the New York Times or the Wall Street Journal or the Associated Press or any other big newspaper or wire service?
So there's a lot packed in there. I want to give you one very specific answer first, and then step back out to the broader context. So specifically, you mentioned demanding an answer right away and cursing them out. The only time that happens is in an email that's about the president's own Instagram account. It's not about moderating other people's content.
Well, again, it does seem like there's an overwhelming amount of evidence that, again, the social media companies were partnering up with the government to play nice to each other and make sure that views that they all agreed with got promoted and the views they disagreed with were censored or otherwise suppressed. That seems to be the dialogue going on right there. But let's continue on. It's very interesting. This is very telling. Justice Alito is utterly perplexed about this relationship between the media and the government, which historically is supposed to be hostile to one another, where the media is trying to get information to the government and the government is trying to stop that information from getting to the media for reporting purposes. But it turns out, according to Justice Alito, it seems to me that the days of them fighting each other as opposed to the media just being a mouthpiece for the government seems odd to Justice Alito. Let's hear what he has to say here.
Yes, I don't want to endorse berate, but I guess I will say I bet this is not the first time that there's been profanity or intemperate language in exchanges between White House or agency communication staff and members of the press.
Well, I don't know whether our public information officer is here today, but maybe she should take a note about this. So whenever they write something that we don't like, she can call them up and curse them out and say, why don't we be partners? We're on the same team. Why don't you show us what you're going to write beforehand? We'll edit it for you, make sure it's accurate.
So, Justice Alito, this is why I want to be careful here. I'm acknowledging the reality that this happens and that it may be commonplace. I'm not saying it's a good thing or a great thing or a thing to be celebrated, but fundamentally I'm saying the First Amendment isn't a civility code. It is an important protection. It's a critical protection against actual coercion, but I think it's important to police that line, and I think this case, the sort of sprawling audit of all of these communications, shows the danger of allowing parties, especially parties without real direct injuries, to come into court and to challenge these sorts of regular back and forth.
Well, I thought that's actually a funny joke that Justice Alito told about. Could you imagine that the U.S. Supreme Court was telling the New York Times, for example, what they should say about the Supreme Court? That would be absurd. And of course, Justice Alito makes jokes about this, but the reality is it's not really a joking matter now, is it? Because there's certain people out there that want to suppress views that they disagree with. And I have a feeling that Second Amendment channels and Second Amendment viewpoints may not be popular in certain quarters of social media. And by the way, let's listen to what Justice Brown Jackson has to say, because she certainly seems sympathetic to the notion that government can indeed restrict speech, which seems to be a little inconsistent with the text of the First Amendment's right of the people to engage in free speech and the right of the people to have a free press. Let's see what Justice Brown Jackson has to say about this very issue.
So my biggest concern is that your view has the First Amendment hamstringing the government in significant ways in the most important time periods. What would you have the government do? I've heard you say a couple times that the government can post its own speech, but in my hypothetical, kids, this is not safe, don't do it, is not going to get it done. And so I guess some might say that the government actually has a duty to take steps to protect the citizens of this country, and you seem to be suggesting that that duty cannot manifest itself in the government encouraging or even pressuring platforms to take down harmful information. So can you help me? Because I'm really worried about that because you've got the First Amendment operating in an environment of threatening circumstances from the government's perspective, and you're saying that the government can't interact with the source of those problems.
And, Your Honor, I understand that instinct, and I guess what I tell you is our position is not that the government can't interact with the platforms there. They can and they should in certain circumstances like that present such dangerous issues for society and especially young people. But the way they do that has to be in compliance with the First Amendment. And I think that means they can give them all the true information that the platform needs and ask to amplify that.
Right, but you're just...
Wow, it almost seems like Justice Brown Jackson thinks the First Amendment is a nuisance that needs to go away so the government can do what it needs to do. And by the way, notice here in this next clip that Justice Brown Jackson seems to be doubling down and liking the idea and viewing the idea that the First Amendment is really just a nuisance to the federal government. Now, by the way, if Joe Biden gets 4 more years, he is likely going to have a chance to put more Brown Jackson type justices on the Supreme Court. So keep that in mind as you watch the next clip from Justice Brown Jackson right here.
If you control
That's not the test for First Amendment violations.
Your Honor, this flows from the plain text of the First Amendment, right?
No, I understand, but we have a test for a determination of whether or not the First Amendment is actually violated. So in certain situations, the government can actually require that speech be suppressed if there's a compelling interest, right?
It can, Your Honor, and I guess what I would say is that the courts below never got to strict scrutiny because the government never raised it. This has never been litigated. The question in this case is whether at the front end the government itself has undertaken action.
Well, Justice Brown Jackson conveyed her progressive sensibilities, which seems to suggest that government is a force for good and not a force for evil, or not a force for coercion or threats or other sorts of potential problems. She seems to think that government is buddy-buddy with everyone. Don't think that's worked out throughout history, but that seems to be where her mindset's at. But let's carry on. Remember how I've explained to you, and I've hammered home this, and I'm happy to say I think the Second Amendment movement has finally completely got the message with the NYSERPA versus Bruin case, and that's this: that whenever you hear phrases like strict scrutiny, intermediate scrutiny, rational basis, balancing test, interest balancing, anything like this is 1,000% terrible. If anyone says this is wrong in the Second Amendment context, that you want any kind of interest balancing, you absolutely reject that and deny it 1,000% of the time. Interest balancing is absolutely terrible, because when you hear the phrases strict scrutiny and intermediate scrutiny, what that is a euphemism for saying that, yeah, we know you have a right under the Bill of Rights. We know you have a right to free speech. We know you have a right to keep and bear arms. We know that. But in this particular situation, the compelling state interest or the interest of the state or the public or the government is so important that we're going to let them violate your rights. You never, ever want, and that's what strict scrutiny, intermediate scrutiny, strict scrutiny, all this stuff is about interest balancing your way. Now, here you have Justice Brown Jackson basically taking advantage of the fact that in the First Amendment context dealing with free speech, you have these interest balancing tests, because the liberal courts over the last many decades have basically created these barnacles on the constitutional system, and they cannot be getting rid of at this point because of the number of precedents. That's the practical reality. But here's an example of how Justice Brown Jackson is trying to use these interest balancing tests like strict scrutiny to justify government infringing on First Amendment rights. Check it out here.
Whether or not the government can do this is something I took up with Mr. Fletcher. Depends on the application of our First Amendment jurisprudence, and there may be circumstances in which the government could prohibit certain speech on the internet or otherwise. I mean, do you disagree that we would have to apply strict scrutiny and determine whether or not there is a compelling interest and how the government has tailored its regulation?
Certainly, Your Honor. I think at the end of every First Amendment analysis, you'll have the strict scrutiny framework in which, in some national security hypos, for example, the government may well be able to demonstrate a compelling interest, may well be able to demonstrate
all right, so not every situation in which the government engages in conduct that ultimately has some effect on on speech necessarily becomes a First Amendment violation, correct?
Maybe not necessarily, Your Honor. I guess the top line question I would ask is, has the government set out to abridge the freedom of speech? That's, Your Honor.
Can I give you a hypothetical?
Case, sure.
Suppose someone started posting about a new teen challenge that involved teens jumping out of windows at increasing elevations. This is the challenge. And kids all over the country start doing this. There's an epidemic. Children are seriously injuring or even killing themselves in situations. Is it your view that the government authorities could not declare those circumstances a public emergency and encourage social media platforms to take down the information that is instigating this problem?
Your Honor, the government absolutely can use the pulpit to say publicly, here's what we recognize to be a public health issue, emergency. This is obviously extremely terrible, and the public shouldn't tolerate this. The platforms, we see it's going on the platforms.
Well, what can you say about Justice Brown Jackson? That's all. I'll let her voice do her own talking. But what's interesting is Justice Brett Kavanaugh had this interesting thing to say, because he's a little perplexed about the notion that a government worker might pick up the phone and call up the press and berate them in anger and say, like, what's wrong with you? And is that a form of coercion by having a government officer, a government employee, call up and berate the member of the press or threaten them or coerce them in some way? Justice Kavanaugh had this to say.
Do you think on the anger point, I guess I'd experienced government press people throughout the federal government who regularly call up the media and berate them. Is that not your understanding? You said the anger here was unusual. I guess I wasn't entirely clear on that from my own experience.
That's fair. I guess I don't want to endorse berate, but I guess I will say I bet this is not the first time that there's been profanity or intemperate language in exchanges between White House or agency communication staff and members of the press.
Now, there was a little bit of common sense discussed. Justice Kavanaugh wanted to understand about what happens if somebody in the media publishes a report that's simply factually false. For example, they talk about the number of troops in Afghanistan that's simply wrong, or they talk about some number that's simply factually wrong. Is it okay for the government employee, for a government bureaucrat to pick up the phone and to call a member of the press and say, hey, we read your article. We just want to let you know that you're factually incorrect. Here's the evidence. Justice Kavanaugh wanted to understand, was that okay? Here's what he asks.
And one thing that I think I want to square up with you is if someone calls and or contacts the social media company and says, what you have there, this post has factually erroneous information. So not a viewpoint that we disagree with, factually erroneous information. And the social media company says, we'll take a look at that. And you still think that's significant encouragement that qualifies as coercion if they take it down in response to it concluding that in fact is factually erroneous?
No, Your Honor. If there's no ask from the government, if the government is just saying, here's our view of the statement.
Okay, and we think it should be taken down. It's up to you, but we think it should be taken down.
Yeah, I think that's a harder case for me. I guess, if you think it's a close case, decide it in favor of the First Amendment.
That's the question here. You can't just claim the mantle. What do you think when you say it's a harder case, why do you think it's a harder case?
Because I understand the instinct, Your Honor, that just asking very, very politely or just saying very, very politely, we think you should take it down, that shouldn't be a First Amendment problem. But the reality is that when somebody like the FBI or somebody like a deputy assistant to the president makes a statement like that, that statement carries force. That's just the reality. My dear mother is a saint, and if she makes a same statement to Twitter, they don't know her from Adam, they don't care, but they do care if it's the government.
So that's really it from the Supreme Court justices. There's obviously a lot more that went on here. I just want to make one reference that there's a case that is often discussed in this context called Bantam Books, a case from 1963 out of Rhode Island. In the case of Bantam Books, what happened there is an ongoing effort to try to suppress obscene material, and there was a commission set up by the state of Rhode Island to review books that were allegedly obscene or pornographic. And what was going on there was that this government commission would identify books that were obscene, they would vote on it, and if they thought a book was obscene, they basically would send out a notice and let distributors and other people associated in the book publishing industry know that the state of Rhode Island viewed this particular book to be obscene. And they asked the distributors and other people in the book distribution process would cooperate with the government to not distribute the obscene book. And this was found to be, even though the government was asking for cooperation, it was viewed as threatening or coercive. And in the Bantam Books case, that system of Rhode Island was struck down as unconstitutional under the First Amendment. So if you hear references to Bantam Books, that's what it's about. It was about a system of Rhode Island involving a commission set up to review books for obscene material, which as a general matter is not protected by the First Amendment historically. Again, we don't need to get into those old precedents involving obscenity right now, but that's what you're talking about when you see Bantam Books. It deals with when does government cross a line and go from simply advocating a particular policy they view to be positive or good for society versus crossing a line, and now they become coercive or threatening or intimidating to force an individual to suppress or adopt a particular viewpoint because the government's basically saying, if you don't adopt that viewpoint, we're going to punish you in some way legally. And that's what the Bantam Book case was really about. The notion of cooperation there was really viewed by the Supreme Court in 1963 as coercion of a particular viewpoint, and that was considered unconstitutional under the First Amendment's right to free speech. So there you have it. Hope you learned something here today. Again, I like to play these clips from the Supreme Court because I think it's important that you hear the kinds of questions that the Supreme Court asks, because at the end of the ironically, these are the exact same people that are going to determine whether or not we have the right to keep and bear arms. In many contexts, I understand there's other remedies out there, other ways to protect our right to keep and bear arms and our fundamental rights, but the court system is an extremely important part of the checks and balances to make sure that our fundamental rights are respected and protected, and we get to exercise them. So that's why I like to bring this information to you, because it's important that you hear directly from the people that are going to be deciding whether or not we have a right to keep and bear arms under the Second Amendment in terms of the court system. So there you have it. All right, folks, hope you learned something here today. Please subscribe. We're trying to get to 150,000 subscribers. Feel free to tell your friends or share the videos and get it out there as best as you can. I'd appreciate that. Don't forget to follow me on X at 4Boxes Diner. We almost have 15,000 people following me on X with my additional Second Amendment information out there, so make sure you do that. And we will see you again soon here at the 4Boxes Diner.
Orders up. Table 2A.